Good morning and welcome to the May edition of Last Month in Criminal Justice, the Centre for Crime and Justice Studies monthly review on all that's been going on in criminal justice in the previous month. And today we will be covering developments in April. We're going to be talking about a new report from the National Audit Office suggesting that we could see a significant rise in the number of child prisoners in the next few years. We're also going to be talking about police stop and search and whether we do need some fundamental reform on that very extensive and significant police power. We're going to be talking about joint enterprise. Why is it that you can be imprisoned for an offence that you didn't actually commit? We're going to be talking also about prisons and mental health and what can be done to address the real problem of mental health in prisons. We're going to be talking about prisons and terrorism. There's a new report out last month from the government's terrorism advisor suggesting that prisons are not currently really dealing with the problem of terrorism in prisons. So we'll be looking at that. And we're going to be wrapping up the discussion with a look at what feels like a bit of a perfect storm growing both in relation to courts backlog, the massive backlog of cases currently blocking up the court system, and the barristers strike, or the no returns policy as it's formally called, where barristers are effectively working to rule, and what that might mean for the court system. As always, we have an excellent panel joining us today to discuss these matters. We're joined by Andrew Neilson, who's the Director of Campaigns at the Howard League. Hello, Andrew.
Hello.
Hi. We're going to be joined by Deborah Sangster, Executive Director of Stopwatch. Hello, Deborah.
Hi, good morning.
And we're going to be joined by Hannah Quirk, who's the reader in criminal law at King's College London. Hello, Hannah.
Hello.
Now, remember, we have the Q&A function. So if you have any questions that you want to pose during the course of our discussion, then do put them in the Q&A and we can put them to the panel, or if you just have a comment that you want to be read out or just to share with the other attendees. And what we'll also do during the course of the programme, we will go in the order that I just listed, and I'll come back to that in a second. So if you do have something to say about our first item on child imprisonment, this would be a good time to start thinking about it and even maybe getting some thoughts in now, because once we move on to the next item, which will be stop and search, we won't come back to child imprisonment. So we may be able to bring it up if it's relevant for a later item. But if you want to get your thoughts in about child imprisonment, then now's the time to start thinking about that. So the Q&A function, which you can find through your Zoom app, and you can pose your questions there. So let's make a start with our items. So the first item is an item on child imprisonment. The number of children in prison in England and Wales is expected to double in the next 2 years. So claimed a report out in late April from the public spending watchdog, the National Audit Office. The report also highlighted the disproportionate number of Black and minority ethnic children in the youth justice system. In the 10 years to 2021, the number of children in prison fell by more than 70%, from over 2,000 to under 6,000, though the rate of decline was slower for Black and minority ethnic children. The trend is likely to be reversed, the National Audit Office report claims, thanks to three main factors: the increase in the number of police officers, tougher sentences as a result of the recently passed Police Crime Sentencing and Courts Act, and the reopening of courts following the COVID-19 lockdown. Andrew, I thought that before we start talking about the implications of the rise in child prisoners, if indeed that's what happens, it's probably worth just reflecting on why child imprisonment fell in the decade past, because it was quite a dramatic fall from the situation in 2010. And why did child imprisonment fall so significantly during the last 10 years?
Well, Richard, as you know, I have a long history at the Howard League now. I've been at the Howard League for a decade and a half, And I remember when I started in 2007, there were actually 3,000 children in custody in England and Wales. So it is very depressing what we're hearing about, because I think it's one of the few real success stories that we've actually seen in the reform sector. The fact that we've gone from that to, numbers below 600. And the big reason for the fall, I think, really is to do with policing practice. In the years running up to me starting at the Howard League in 2007, we were looking at New Labour's old offences brought to justice targets, which ranked police forces and how many arrests they made. These were mandatory. It encouraged the police to effectively arrest first and ask questions later, and children were low-hanging fruit in a sense for that. The Howard League has run a campaign for many years since about 2010 on this issue of child arrests, and I'm not suggesting that's the only reason why we've seen the big drop in numbers, but I certainly think policing practice did drive a huge amount of the change, because if the children weren't coming to the attention of police and having that police contact in the first place, then they were less likely to then go down all the various stages of the criminal justice system, all the way down to custody.
Mm. And I mean, it was a kind of as you say, it was a sort of an unsung kind of, success of the coalition government. But I suspect it was probably something, it wasn't, as you were suggesting, it wasn't, they didn't plan. They didn't say, we are going to reduce the child prison population. This is an important priority for us. It happened kind of, as it were, incidentally, as a result, as you say, of changes in policing practice, crucially. And I'm sure that organisations like the Howard League, and you weren't the only ones, but you were certainly doing a lot of work in this area. I'm sure organisations like the Howard League certainly played an important role in helping to focus minds on what could be done differently. But the fall was not evenly spread, and certainly Black and minority ethnic children were not as much the beneficiaries, as it were, of this dramatic fall as white children were. And Deborah, I think you might have some thoughts you wanted to share about that.
Simply, if you look at the numbers of young people who are in youth offending institutions, it looks like Britain is a black country. So what's that about? I know it's becoming increasingly unpopular to talk squarely about racism, and it's even more unpopular to talk about racialized justice. But unless we talk about racism, we talk about adultification of Black young people, we're not going to be able to make sense of why Black young people are still disproportionately imprisoned. I think the pipeline between stop and search and disproportionality and young people in prisons disproportionality hasn't been cut. And I think that one inexorably leads to the other. Yeah, that's yeah.
And we're going to get on to stop and search shortly, and I think there's some very clear, politely referred to sometimes as ethnic disproportionality in stop and search, and indeed in our item on joint enterprise as well. There are some troubling trends there again, where young Black kids and young Black males in particular seem to be very strongly targeted, or seem to be much more people of interest, let's put it that way, of the justice system than their white counterparts.
I guess it's interesting that we're still trying to call it a justice system. I think there's something systemically wrong with the systems of justice that are applied, because they're in no way even-handed, and that has to be, we have to reflect on that. Sometimes I would say a difficult thing to hear, difficult conversations. We really need to approach it squarely. And if we're talking about injustice, then we can see how injustice is working for Black young people. But the systems of justice are not being operated fairly.
I think it's where we need more data as well. If we look at the reasons why young people, any offender is given a custodial sentence, I suppose in particular the facts, disparities in offending behaviour as well. So, for example, if the courts were having to impose custodial sentences for knife crime use, that the fact that there is a disproportionality in knife crime as well, that I think we obviously need to be very sensitive to to issues of where individual practice of police officers or sentences is having an unfair effect. But I think sometimes just looking at the crude figures can be quite misleading as well, that we actually need that kind of really deep look into the data to see are like offenders being given similar sentences, or is there something different at play as well?
I find the data is interesting, I think, and data can tell us a lot of things, but our eyes can tell us stuff too. And for people who are not Black, looking at a youth offending institute and seeing a disproportionate 53% in some cases of Black young people imprisoned, if that doesn't feel wrong, then the data is not going to tell us anything. The data is going to be used to justify. But if we also hear from what's happening to young people, where they are being arrested alongside their white counterparts, and the Black young people are imprisoned and the white young people are given a community sentence, you know, there's so much that data can tell us, and we can interrogate the data ad nauseum, which we are doing in Leicester. At least we are doing, we know lots and lots and lots about the data. But what that's not telling us is what we need to do about it, because ultimately the question of what to do says it says that we need to end racism, that we need to explore what the data is telling us through the lens of racism, and our systemic racist practices can't cope with that. It's like a truth that dare not speak its name.
We could equally say most young offenders are male.
And they are Black.
Does that mean the criminal justice
and they
system
are Black?
Sexist?
And they are Black. They're not. You're not one thing, are you? You were
saying just because there are some groups are overrepresented is therefore racist. I'm not saying there isn't racism for a moment, but I think it's too crude sometimes just to say we need to actually look at what factors. Is it a class issue? Is it policing issues? And
people who are Black are also working class. People who are Black are also, so all of these things intersect for Black people, don't they? So whilst it might be crude, that's an interesting word, whilst it might be crude to say it's racism what done it, yes, I accept that. Yeah, we can find lots and lots of clever ways of saying it's racism what done it. And so the time that we're spending trying not to call racism, we're equally spending time on not addressing how racism is operating. That's my feeling.
Yeah, and there was this sort of the Lammy review, which, you know, was for many people, I think, was disappointing in parts. But I think that notion of, you know, institutions need to be able to explain or reform. I mean, I found quite a sort of a helpful way of thinking about it, you know, because as you're saying, Deborah, if, you know, a massively disproportionate number of prisoners in young offender institutions are Black, at least in principle, there may be, as it were, a reasonable explanation for that. It's difficult to see what it would be, but at least in principle, it might be. But, you know, in practice, if one can't explain that, then the argument was something needs to be done to address what is, you know, otherwise seems a profound injustice, you know, that a particular group of people being targeted, you know, at least in part because of the colour of their skin, you know, that's, as you were suggesting, is not, I think that's this kind of sign of a justice system working healthily.
Yeah, I mean, I was just going to say, I think explain or reform was a useful thing for Lammy to say. I think the problem with the way that it's been applied is that it's still being applied to silos and not sufficiently joining. So there's an extent to which Feltham Prison would struggle to explain why so many of the young men that it holds are Black. And actually, it's not Feltham Prison's fault in that sense. It's at the end of the pipeline. I think what Deborah was saying, and I know we're about to talk about stop and search, but, you know, clearly a big reason why racially minoritized children are still getting a lot of police contact in a way that other children aren't, since those targets that I was talking about earlier have gone. And you can see that in the figures for the Met, for example. I mean, we published our latest kind of figures around child arrests, and between 2016 and 2020, Met arrests of children dropped by 1/3, but the proportion of racially minoritized children who were arrested went from 60% to 64%. And so it is clearly the reductions are benefiting white children disproportionately, and that is just exacerbating the issue. And it is something the Howard League is about to start a new project on around racial disparities in youth justice. In fact, we've got member staff starting next week to start looking at that particular topic.
That sounds interesting. Before we move on to the next item, let's just, I mean, we saw a significant drop in the youth custodial population. The National Audit Office report effectively says, well, because there's going to be more police around to arrest people, courts are going to be, cranking up, so there'll be more prosecutions and convictions and imprisonment. There are tougher sentences. So there are kind of some particular pressure points in the system which might result in rises. But Andrew, I mean, is the last 10 years where we saw a significant drop in the child custody population, are we going to look back on that in a few years' time and think, well, that was kind of almost the exception, as it were, that it was an exceptional set of circumstances, and unfortunately, an exceptional set of circumstances, and actually, therefore, the rise in the youth custodial population, it's a bit of a return to business as usual. Do you think, is that how you see it?
Well, I've got two things to say. One is depressing and one is maybe more optimistic. So I'll do the depressing thing first, which is that I think what we will do looking back is see a missed opportunity, not just on this question of race, but on the question of what youth custody is like. Because if you manage to reduce the numbers of any type of prisoner by 2/3 or more, then you should ideally be able to reinvest the money to a degree in improving custody for those few children or any type of prisoner who are left in custody. And that is not what we've seen. I mean, conditions in young offender institutions in particularly are worse, I'd say, than they were back in 2007. And so that is a missed opportunity. And of course, if numbers now start to grow, then what is it going to look like once more pressure is put on those prisons? If I was going to be optimistic, though, what I'd say is I do hope that these projections are actually going to turn out to be wrong, because I do think that the factor that the NEO identified that will probably impact on children the most is this issue of increased police numbers. And when you look at the way the MOJ projects this rise in prison population, there is a bit of a back of the envelope maths to it. They are saying X amount of extra people will be arrested, Y of whom will be children, Z of whom will end up in custody. And I'd like to think that there's plenty room there for police practice and practice at other stages of the criminal justice process to stop that from just automatically being the case, that just because we've got 20,000 extra police officers, that must mean that, more children will be jailed. But we'll wait and see.
Yeah, the specifics of particular police practices are obviously an important missing element there. Thank you, Andrew, and thank you, Deborah and Hannah, for your thoughts as well. Let's move on to a particular example of police practice, and indeed a very controversial one at that. The officer dragged me out of the car with a raised baton and handcuffed me. He falsely alleged that he could smell cannabis on me and recorded this as the justification for the search on the stop and search form. These are the words of the Portuguese sprinter Ricardo dos Santos, explaining what happened to him and his partner, British sprinter Bianca Williams, when they were stopped by police in London in July 2020. Bianca Williams was also handcuffed. Their 3-month-old baby was also in the car. 5 Metropolitan Police officers are facing gross misconduct charges over the incident. In another case from 2019, but only recently reported on, and I actually came across it via the excellent Stopwatch newsletter, a Somalian-born Londoner was stopped, searched, had his immigration status checked, and was then challenged to a fight by an on-duty police officer after his car developed a flat tyre. This is the chap who was stopped. His car developed a flat tyre. He had to pull over to try to deal with it. The officer involved was given a written warning. This all comes as the Independent Office for Police Conduct issued a highly critical report on the police use of stop and search. In one case highlighted in the report, a teenager was stopped 60 times over a 2-year period between the ages of 14 and 16, leaving him feeling intrusively and relentlessly over-policed. I'll leave you to guess what the ethnicity of this young person was. Deborah, Bianca Williams described a culture of racism in the Metropolitan Police. You've already spoken a little about this at a broader level, but is the ordeal that she and Ricardo dos Santos went through, is that unusual? Is it kind of a few rotten apples, as it were, or is this kind of fairly common in the way that the Metropolitan Police are dealing with Black and minority ethnic population?
I would suggest that it's more tree rot than a bad apple. I think that Bianca was lucky in the extent that she's famous, and therefore her experience reached the national news. The experience for people who are stopped and searched who are not as famous or as well known as Bianca is very similar to the experience that she has described. Is there a culture of racism? Well, we're going to get a lot of data, because I think the Home Office is changing the way the data is collected. We're going to get a lot of data coming to explain that it's not racism, but we're still going to be left in doubt as to what exactly the reason is. I mean, when we're talking about systemic racism, I'm not suggesting that, every policeman and woman goes to sleep in the night and wakes up in the morning saying, I know how I'm going to get those Black people. But there is an expectation that crime and criminality is gendered male and is predominantly, or at least we can expect that crime to be both male and Black. And Stop Search kind of takes that as its starting point. So if that's the starting point, where did it come from? Because it's not simply Black people who are in London, that's the Met. It's not simply Black people who are in London who are over-policed. Black people in rural areas, Cumbria, for example, and there are so very few Black people in Cumbria, are also over-policed. And again, we are struggling to find a word to explain what the over-policing is based on if we don't talk about racism. So in answer, yes, Bianca Williams's experience is mitigated by her fame, and in that her fame made it come to national attention. Her experience reflects the experiences of other Black people who were stopped and searched. I would argue it's more of a tree rot than it is bad fruit, and that we need to be, again, squarely talking about racism in its many forms to begin to understand what that is about. So if we say glibly a culture of racism, it's a good headline, but what does that mean? Yeah.
And of course, I mean, whilst, I think all the evidence does suggest that, that Black and minority ethnic people are disproportionately stopped and searched by the police. Numerically, lots of white people are also stopped by the police. And I guess the kind of one of the wider questions here is, is this an issue of, the police just should not have the power to stop and search people, full stop? I mean, some would argue that, wouldn't they? Just take the power away completely. Others would argue, well, the power needs to be more limited. It needs to be more targeted. It needs to be, there needs to be more checks and balances around it, or there needs to be a whole different kind of way of dealing with these issues. So, I mean, what's the Stopwatch position? I mean, does Stopwatch have a position on stop and search per se? Is it a power that you recognise might be needed but needs to be, hedged more, or is it a more fundamental reform that's required?
It needs a fundamental reform. But I think that we need to look at the police services that are overusing stop and search in relation to their Black communities. And how do we remove that power? How do we suspend that power? What are the systems that need to be in place for those services that are disproportionately stopping and searching Black people to demonstrate that they're actually addressing their disproportionalities? Of course, like anybody else, I wouldn't want, to be robbed or mugged or otherwise harassed. And if stop and searching somebody who's will stop that, yeah, fine. but that stop and search can't be disproportionately impacting black people without it being, because what's being said then? So in total, the power needs to be at least reformed. Police services that are found to be disproportionately using that power against black and minoritized people, they need to have the power removed, and a system of corrections need to be put in place and evidence before that power is returned. We have to do something radical, because what's happening now is becoming so matter of fact that we tire of talking about it. And at those points, black communities are viewed as, oh, simply complaining, just get on with it, rather than it being recognized as a fundamental assault on both our rights as citizens and our rights as human beings in UK.
And I mean, both the cases that I mentioned in the introduction, the police officers are facing or did go through a disciplinary process. Now, one can argue about, whether the right outcome, and we obviously don't know in the case of Bianca Williams what will happen there. But, I guess some who defend the current approach would say, look, what's the problem here? When abuses are identified, the police officers involved are face disciplinary action or retraining or challenge. It's actually, what's the problem? I mean, what would your thoughts be on that?
For me at least, the numbers of police officers who are disciplined as a result of their racialized stop and search practices is minuscule compared to the numbers of black people who are stops and look. More than in Leicester, at least, more than 70% of stop and searches result in no action. All right. If you were making widgets, if you were making cars, and 70% of those cars were duds, not usable, came to nothing, would you say, oh, we'll keep doing it because 10% is a good outcome, or would you say we need to do something else? I think we've arrived at the place where we need to be doing something else. And whatever that decision is, it has to be, God, I sound like some bloody liberal, but it has to be with consent. It has to be with the communities you're policing. So you need to be in and of the communities you're serving to be able to make an impact on A, crimes in the area, and B, the way the police are viewed in the area.
But again, with the disproportionality, if we look at figures, and I accept there are some incidents that are indefensible, but again, just to say the figures are disproportionate doesn't necessarily mean that it's discriminatory or hostile, or if we look at the figures for something like 2/3 of knife offenders in London are black. So now again, that may be a slight chicken and egg feature. But if we look at the population of London as a whole, stop and search is concentrated in certain areas. And Gavin Hales has done some quite interesting sort of ward level analysis of, if you look at the areas where you'll have the most police stop and search activity, because you've got high rates of street crime going on, they are majority black wards. So of those available to search, they will be black. So that there are discrepancies that aren't necessarily malignant. And again, I'm not saying that there aren't incidents that are wrong, or that some police officers are overly suspicious of young black men in particular, but we also need to look at the fact that we're looking at high crime areas too.
I really like the phrase discrepancies are not necessarily malignant, unless you're black, of course. So
I'm saying it's not necessarily racist. There are different levels in, a number of factors that aren't necessarily due to racism. They may be, but not necessarily.
Okay, two things. First of all, my mum said you'll find what you're looking for. It was a curse when I was 16, because she was telling me not to do that, because I will find what I'm looking for, and I did. My child is now a particular age, but anyway, that's not the point. My point here is, if the police are tasked to look in particular areas, they will exactly that, find what they're looking for. If the starting position is that we suspect black people are more criminal than their white counterparts, then you will go in finding that. If the police are looking for knives and they concentrate on areas where there are young people, they will find knives. If they concentrate on areas where, I mean, the whole knife crime is another argument again by itself. What I'm suggesting is that unless and until racism in its many forms is squarely and centrally addressed, we'll be skirting around it. We will continue skirting around it without ever looking at it, without ever identifying where racism is. I mean, you know, of course, Miss Quirk, that racism is more than being called a very bad name. We know that. We also know that systemic racism is more than the choices one police officer takes or makes in who should or shouldn't be stopped. That the systems that lead to that officer making those choices are where the investigations need to be, rather than in the outcome of those discriminatory practices. So let's look further up the chain. Let's look at where decisions about where police are placed are made. Let's look at where decisions about what is important to police are made. Let's look at how the police work with and make communities feel safer. Let's look at where those decisions are made. I think unless we look at how the systems work, we're going to forever say, yes, it's racism. No, it's not. Yes, it's racism. No, it's not, which doesn't really get us anywhere. But what it does do is set up a kind of binary opposition, doesn't it? When really it's more involved than that. But we can't avoid looking at that racism. I mean,
there's a kind of a system complexity here, isn't there? It's a bit like what we were talking about with child custody. You know, that changes in policing over there has effect on the prison population over there, and stop and search is maybe a really good example of that. But I think what this discussion has also shown me is that, this is an excruciatingly difficult set of issues, where people have really grounded and profound and strong views about about this issue based on their experience and based on analysis and based on their own research. And I think what we try to do in this discussion is to start to tease some of those out in a way where we recognize we're all kind of trying to think this through. And I really appreciate, I think, both, Deborah, your comments and Hannah's comments, just to kind of, let's try and think through what we're talking about here. And it's been a really fascinating conversation, but alas, we have to move on to the next item. On joint enterprise. So thank you both for your thoughts on that. Our question and I was about to say our question and answer is looking very quiet at the moment. We've just literally, as I was about to say that, Hugh has just made this observation. The most overrepresented groups in prisons are the travelling community, and the least are Indians. I think it means most in the Indian subcontinent, at least definitely. There is a near perfect correlation with overrepresentation rates with poverty as measured by ethnic rates of free school meals. Interesting thought, Hugh, and thank you for sharing that with us. Let's move on to our next item. Do keep those questions coming in and observations coming in as the mood takes you. We're going to be talking about joint enterprise now, and after that we're then going to be talking about prisons and mental health, prisons and terrorism, and then we're going to round off with the court's backlog and whether we're facing a perfect storm in relation to the criminal courts and the barristers' no returns policy or strike, however you want to define it. So any thoughts on those? You might want to get your questions and observations in now, but let's move on now to joint enterprise. If you're among a group of friends that attacks and kills a stranger who dies as a result, you might expect to face a murder charge. But what if you're nowhere near the fight, or you choose to walk away at the first sign of trouble? Under joint enterprise rules, you could still be prosecuted for murder. Another example, under English law, rape can only be perpetrated by a male. Under joint enterprise rules, however, a female can still be convicted of rape if she was deemed to have assisted the primary male offender or offenders. In 2016, the Supreme Court concluded that some of the rules on joint enterprise had been wrongly applied for 3 decades. Hopes were high among justice campaigners that some, at least, of the injustices of wrongful conviction under joint enterprise rules would be addressed. But 6 years on, a new report from the Centre for Crime and Justice Studies, out in April, found no discernible impact of the Supreme Court ruling. Moreover, the disproportionate prosecution of black males under joint enterprise rules appears to have got worse since the 2016 Supreme Court ruling. Hannah, is there, I mean, it's a very controversial set of rules, a bit like stop and search in a different context. Is there ever a good use of joint enterprise rules to secure a conviction, do you think?
I think there is, and it was originally like a common law offence, so the courts created it, and then Parliament created a statute in 2007. So if you and I decide to go and do a burglary or an armed robbery, let's say, so I'm driving, I've checked all the bank, what time the money arrives, I'm driving the car, you run in and take the money, and I drive off with you, we can both be found guilty of the same offence, because even though we've played different parts in it, we've both contributed to it. So the joint enterprise laws are to, sometimes where it's very difficult, let's say, 4 people are beating somebody up, it's hard to determine who exactly struck the fatal blow. If you've all taken part in that enterprise together, it's a workaround almost for where you're all seen as guilty of the same offence. I can see an argument for separating the two and saying, there is something fundamentally different about being the person who goes into the bank and commits the robbery or makes the fatal stabbing, for example. But essentially the crime is based on that you've done something together. You both wanted to commit this criminal activity and you both took part in it. The difficulty with the case that the Supreme Court looked at was where this had sort of expanded. So it's fairly straightforward if you and I both decide to go and commit a robbery. The difficulty was where that sort of expanded. So and many of these cases were, let's say, a burglary. So we've decided to go and burgle somebody's house. In the course of the burglary, the homeowner comes in and I stab them. Now, you had no expectation that I was going to use any violence. You just thought we were there to burgle the house. Under the pre-Jogee law, you could have been convicted of murder with me, because if you sort of had an expectation that I was a bit violent, and that could have happened. The Supreme Court used this lovely phrase where they said the law had taken a wrong turn 30 years earlier, like it was this sort of confused tourist rather than it was actually a decision made by judges. So it was this very sort of distancing language that they used, and they said that it should really only be used where you've got a foresight of what was going to happen. So there were lots of campaign groups around this area thought that the more tightly drawn law would be beneficial, and that many of these existing convictions could be overturned. The Court of Appeal wasn't very keen on the Jogee decision, and they put in an extra hurdle to quashing convictions, and they said that the applicant had to show there'd been a substantial injustice by the fact that they'd been convicted under this wrong law, which has never, as far as I'm aware, been used on any other kind of appeal before, and have only quashed 1 conviction so far.
And that the so-called substantial injustice test is itself the subject now of a potential private members bill that the campaign group Jengba is seeking to get through Parliament to at least make it easier for those who feel they've been convicted unfairly under joint enterprise rules can seek a fresh appeal. And we discussed that in the March edition of last month in criminal justice. So it is a kind of a significant issue. I mean, you say that, since, 2016, in principle, that situation, I think the Jogee case was precisely that, wasn't it? It was 2 people who were burgling a house. Jogi, who was the person who appealed, was in a different room. I think may have been downstairs in the house or something like that. May not even been in the house, I can't quite recall now. And his co-offender stabbed the homeowner. And I think at the time when the rules were applied, the assumption was that he should have been able to foresee such an happening. And what the Supreme Court effectively said was, you can't expect people to gaze in a crystal ball. But certainly what we found when we looked at this was a significant amount of flex. That the CPS and prosecutors were just finding another way to effectively get a similar outcome by flexing the rules in a slightly different way, and which sort of made us wonder really, the degree to which the justice process is remarkable in its ability to just kind of flex and adapt to judgments or other kind of changes which maybe courts or prosecutors don't like the look of. So as you said, Supreme Court, appeal court said, oh, well, let's introduce this new test. I mean, is this all kind of suggesting that actually trying to get significant meaning or reform on something as fairly fundamental as joint enterprise is just a real kind of uphill struggle, because courts always seem to find another way to have the same effect?
I think courts have got more discretion here because it is a common law offence where they've got to follow an act of parliament. Then obviously there is some scope for flexibility.
So just explain in a nutshell the difference there, because I think people don't always understand the difference between common law and legislative law. No, I mean, it's really, I think it's important. I mean, I'm asking for myself as much as anyone else.
So common law sort of comes from the judges, so that there isn't an act of parliament. You can't go and read the act that says, you must not murder people, and this is what murder is. That's just kind of developed over the years through judge-made law. Most offences now are found in statute. So there's an Offences Against the Persons Act, which tells you what GBH is or ABH is. So you can go and look up the wording. Now, obviously, it's up to the courts to interpret what actual bodily harm is or what your intention is. So they can interpret those words, and there's scope on that. But an act of parliament can make it more difficult if it said, these are the things the court has to consider. It ties them in a little bit more. Because joint enterprise was sort of a judicial creation, they've got a bit more scope for interpreting it. But I have to say, it does seem an extraordinary step by the Court of Appeals to introduce this substantial injustice test. I've not seen that in any other kind of appeal before. They're always very aware.
Would that judgment itself therefore be appealable? I mean, if you say it's a really unusual.
Yes, it theoretically could go to the Supreme Court. But it's, I've totally forgot what I was going to say, sorry.
My apologies.
That's fine. Senior moment. The Court of Appeal is very wary of, it's come back to me now, is very wary of floodgates, and that they'll be inundated with these cases. So you sometimes see they have quite a liberal appeal almost. They interpret the law quite generously and then panic and make it much more difficult. But certainly with the joint enterprises cases, right from the start, they've been very, very tight about what they would allow through.
So what you effectively have is, if I understand what you're saying, is with joint enterprises, you have a kind of an interaction between, statute law, this is what ABA or, grievous bodily harm is in legal definition, an interaction between that and common law, between sort of law which has been created by judges, and kind of that's where maybe some of the, kind of interaction effects are taking place, which are leading to some rather strange outcomes, like, for example, female defendants being legally found guilty of rape, even though in statute law it's impossible for a female to commit rape. Yeah,
so I mean, that could be something like Rose West, who I think was convicted under joint enterprise, whereby if she procured the women and brought them back to the house, and knowing what was going to happen and for the purposes of rape, then she could be found guilty as part of that one offence. It's a slight anomaly, but it's rape's a strange example where a woman can't be convicted as a principal, the person who's actually done it, but can be convicted as the secondary.
But this is where we saw this, and a number of people got excited about this for another reason. Excited is the wrong word, but got picked up on these figures for another reason. That was like over, I think in the criminal statistics, over 400 female defendants were convicted of rape in about 6 or 7 years, up to about 2020. And I think a number of us saying, well, that must be wrong. There must actually be male defendants who've been wrongly categorized as female or something. But actually the joint enterprise process might, at least in part, explain some of those convictions, not necessarily all of them, perhaps, but might at least explain some. Before we move on to the next item, Andrew, I don't know whether you have any thoughts. I know Howard League has done work in the past and probably also in the present on the whole joint enterprise issue. I don't know if you have anything to add to what Hannah was saying there.
No, just it seems to me to be as good an example of any of the overweening focus on the whole rational actor concept in our justice system, and the extent to which privileged middle class members of the judiciary expect less privileged people before them in court to act in incredibly rational ways, considering all the different things that might happen if they enter a house on a burglary, for example.
Or purely just the heat of the moment, what happens in those, and the degree to which you can be responsible for your co-offender in the heat of the moment doing something. Okay, well, we'll come back to this issue. I mean, the research that we published in late April, is not the final piece of work we'll be doing in this area. So I'm sure we'll.
A really interesting report, though. It's a very good read. So.
Yeah. Well, no, I mean, it was. It's my. I can take very little credit for it. It was, my colleague Helen Mills who really kind of brought the whole thing to fruition from start to finish, actually, and working with other colleagues, Roger and Matt. So it was important piece of work, and I'm glad that we were able to produce it. And we will certainly circulate the details of that report, and indeed all the other things that we've discussed in this programme with a follow-up email. But we need to move on to the next item now, where we'll be looking at the question of prisons and mental health. The Independent Advisory Panel on Deaths in Custody provides advice and expertise to ministers on deaths in custody and how such deaths can be avoided. In early April, the panel wrote to the Justice and Health Secretaries, that's Dominic Raab and Sajid Javid, calling for a thorough review of the impact of extreme imprisonment on the mental and physical health of people detained by the state. The letter, co-signed by health bodies, unions and selected charities, argued that the 2 years of COVID lockdown in prisons, with most prisoners being confined to small, badly ventilated cells for up to 23 hours a day, had created a desperate situation. Also this month, the all-party parliamentary group on women in prison in the penal system published a report detailing filthy living conditions and alarming evidence about self-harm among female prisoners. The group called for urgent action to stop the unnecessary imprisonment of women. And in another report, the independent monitoring boards, whose members make prison monitoring visits, and the Criminal Justice Alliance published a damning assessment of racism and discrimination endured by Black and Asian female prisoners. So a lot to discuss here, and we don't have much time to talk about it. Andrew, the extreme lockdown in prisons that the Independent Advisory Panel referred to may have prevented much higher number of COVID-related deaths among prisoners than I think a number of us had feared would happen. But it has been at the expense of significant levels of mental health distress amongst prisoners, hasn't it? So, I mean, going forward, what does the prison system need to do now urgently, really, to kind of try and address this kind of terrible situation that so many prisoners?
That's a huge question. I mean, I think what you're absolutely right that what we've seen is a narrative from the Ministry of Justice, which certainly has, and understandably, put an emphasis on the extent to which the spread of COVID has been stopped, and therefore deaths have been stopped by the lockdown measures. And there was, I think, last year, a narrative emerging because of the safety and custody statistics. For example, self-harm incidents were falling, and they are falling. That somehow not only was COVID stopped, but more stable regimes were in place. Prisons were less violent, and prisoners were being apparently less violent to themselves, although of course that's incidents that are recorded, and if staff aren't getting behind that cell door very often, then what is actually going on? I think what we are now seeing is increasingly from people. I mean, you mentioned the joint letter from the IAP. I think the IMBs as well are very important in what they've been reporting on the ground. I think we are now starting to understand that actually there's a huge amount of unmet mental health need that is not captured in these statistics, and which is getting worse because of what's going on. I mean, the Howard League surveyed our own prisoner members and our members who are relatives of prisoners in the last few months, thinking about the 2-year anniversary of the first lockdown, and we've just published a series of blogs on the findings of that survey, and mental health really was a key theme. The responses did describe widespread mental ill health during the pandemic, with little support from professionals, family members unable to help relatives whose mental health was deteriorating in prison because, of course, they were unable to visit them, and that suspension of visits in turn was affecting their mental well-being. So there is very definitely a big problem, I think, that is being stored up. But that doesn't answer your question, because I think that's really the tricky bit. I think the prisons the prison service is very aware of the challenges they face. I think
there is a sort of a pressure, isn't there, to kind of say, well, actually, it's worked quite well having all these prisoners. Yeah, so maybe we should continue.
I think there is a pressure there, but I think that pressure is more actually to do with the situation as prisons face in terms of their staffing than anything else. We've seen quite a lot of staff turnover over the pandemic, a lot of new staff coming in, new staff who have never experienced prisons before the lockdown. So they never experienced a prison system where every quarter there were new record highs of assaults and self-injury. So you can, I think there is an understandable, worry within the prison service about how that new staffing group copes with a prison system unlocking in a way that it would look like, back in 2019. But I don't think that can be used as an excuse to keep prisons as they are. And I suppose the devil is in the practical detail, is how do you chart away from where we are now to something much closer to where we were in 2019, but without the violence and without the ever-rising self-harm.
And Hannah, I think we, in an earlier edition of last month in Criminal Justice, I think you were one of the panelists, we talked about self-harm statistics, and at the time they were looking quite concerning, in terms of prisons. And I seem to recall there was a distinct gendered dimension, that actually, self-harm amongst female prisoners did seem to be rising. And if we then add that to, the report from the Independent Monitoring Boards and Criminal Justice Alliance on racism and discrimination faced by female prisoners and Asian prisoners, the all-party group, concerns about the state of women's imprisonment. It does kind of sound like, maybe not unlike a number of other public services, prisons are in a pretty dire state, trying to adjust to what's been a very traumatic period, actually, for prisoners and prison staff.
And has been completely hidden away for the most part. And there were concerns at the start that COVID would sweep through the prisons, and I think the death rates were high. I've actually found it quite useful for talking to people about the length of sentences we impose. If you hear on the news someone's only got 2 years, people tend to think, oh, that's quite a lenient sentence. And if you say to somebody, think back to pre-lockdown, that's what 2 years feels like, of not seeing your family, of not having a hug or any kind of physical contact unless it's violent. I think that it's perhaps quite a useful way of making the public think what imprisonment, the pains of imprisonment, we talk about what that actually feels like for people. And again, it's just going back to the previous item about the rise in young offenders. It's so depressing that we're just talking about racking up numbers again, instead of, can we actually do something constructive with the people we need to incarcerate, because undoubtedly there are some people we do need to, but making those conditions better, because nobody's going to come out of prison helped in any way really if they're just locked up for 23 hours a day and in a fairly brutalizing regime.
It does kind of pose a question which we don't have time for now, but the degree to which it's ever going to be possible for prisons to be respectful, inclusive and rehabilitative places. And certainly the current situation doesn't look good, does it? But let's see whether we'll keep an eye on this one. But I want to move on to our next item, which is also prisons related, but also has wider kind of, as it were, political and social dimensions to it. And it's about a report that came out from the government's advisor on terrorism in relation to prisons and terrorism. It was in late April. In response to that, the Justice Secretary announced plans to expand closed supervision centres, which are effectively kind of prisons within prisons in a sense, for prisoners deemed to pose a particular risk. Dominic Raab, the Justice Secretary, also said that prisons would, quote, take a more decisive approach, not allowing cultural and religious sensitivities to deter us from nipping in the bud early signs of terrorist risk. And he claimed that the government's plans for a Bill of Rights will prevent terrorists from using the Human Rights Act to claim the right to socialise in prison. And this was all part, as I said, of an official response to a report by Jonathan Hall, the Independent Review on Terrorism Legislation, who'd raised concerns about the way that prisons were currently dealing with terrorism, those who've been convicted of terrorism offences in prisons. Deborah, we'll come to the kind of the more specific questions around prisons in a minute, but it was 20 years plus since 9/11. It's more than 15 years since the sometimes referred to as the 7/7 London bombings that many of us who were living in London at the time will remember well. Are we any better now at guarding against what we might call religiously justified acts of terrorism, whilst also ensuring that the peaceful expression of religious views, including religious views which might be controversial, are allowed in a plural society? Do you think we're any better than we were a decade ago at dealing with these issues?
I don't know, but what I do know is that focusing on religion and terrorism kind of skews the argument, doesn't it? And it tells us who we are constructing as villains, as terrorists, and therefore making it permissible to be treated as such, and who we're suggesting the innocents are, and making it permissible to be treated as such. Ultimately, it comes to a question of social justice, doesn't it? What do we mean by terrorist, and what is the purpose? What are we trying to do? What are we trying to get to?
Well, I could give you quite a clear example. If you look at the Fishmongers Hall attack, where 3 students were stabbed.
Yeah, and how did that prisoner, ex-prisoner, get to the situation where he was in a position to attack anybody? What systems had been in place, and what systems failed there?
Multiple failures, obviously, but it was still his responsibility.
His as an individual responsibility, obviously.
But I don't understand your point about constructing a terrorist.
No, I didn't say him. That's not what I said. What I said was, if we're looking exclusively at terrorism and religion in the way that the question was framed, then that is going to tell us where we need to look for the villain. And that is again, I would argue, denying people's rights to religious freedom. But if we look at what we mean by terrorist more roundly rather than religious terrorist, then I think that might be a more useful way of ensuring equality in what we're doing.
Deborah, the journalist Joan Smith published a book last year where she was really arguing that actually, if we're interested in extreme acts of violence, which we would describe as a terrorism, then actually many of these perpetrators have had a history of of other forms of violence, typically sort of male violence towards their girlfriends, their wives, their partners, their other members of their family. And if it is the case that religion in and of itself is neither good nor bad in that sense. There are plenty of people who express quite strong religious beliefs who don't feel the need to express them in a violent way in what we might call terrorism. So is this more about male violence, which is being expressed in a particular direction, which might sometimes be in the mind of the perpetrator being justified by their strongly held religious beliefs, which doesn't mean it's motivated by religion, but it's certainly being, so I use the term religiously justified acts in my introduction. Do you think is it about the kind, just a broader issue here about male violence, which is expressed in particular ways, sometimes quite dramatic and awful ways?
Well, that's an interesting idea, but again, men are not a blob of humanity that is just gendered male. You're black, you're not, you're married, you're minoritized, you're not, you're gay, you're not, you're disabled, you're not. So what kind of men are we talking about? And how does that help us? How does that help us to understand what's going on, is my question.
Well, and I suppose the argument that Joan Smith would make is that, perhaps if we were more focused on dealing, rather than, as Dominic Raab says, nipping in the bud terrorism risks by focusing on, by focusing on religion, instead saying, well, actually, if a man is on an escalating pattern of behaviour where he keeps beating up his girlfriend, doesn't mean he's going to end up being a terrorist, but actually, perhaps if we dealt with that more effectively, we would maybe find that small group who then, as it were, graduate to serious acts of mass terrorism. We might be more effective at dealing with it in that way. I guess that would be the argument. And then it's neither a racialized argument in a sense, nor is it an argument based on religious belief. But anyway, just a thought. I mean, it struck me as an interesting thought. I mean, thinking maybe more specifically about the prisons dimension, which is where it came from, and the report from the terrorism advisor was prompted partly by the Fishmonger Hall incident, and it was a review of kind of some of the undoubted failings, I think, at various points in the system, which very tragically resulted in those deaths of the students. But Andrew, is the problem of terrorism and extremism within prisons, is it being overstated? Is it as big an issue as maybe Dominic Raab is making it out to be?
I think possibly in some prisons. It's an issue. I think in the system as a whole, I think it probably is overstated. And we're still not always getting to the bottom of perennial cultural issues that have come up in these discussions. So I remember again, sorry, I'm sounding like I'm a lot older than I actually am, but many years ago, I remember a report into Whitemoor Prison where there was a lot of concern around radicalization in that high security jail. And it turned out that actually quite a lot of what was going on was just Muslim prisoners grouping together because what they had in common was that they were Muslim prisoners. And then a primarily very much white staff. High security prisons are often in faraway rural locations, and then the staff are from that locality, but the prisoners are not. That staffing group found it very difficult to differentiate between groups of prisoners who were forming friendships, gangs even, as a mutual self-protection thing, and because they had something in common, and then whether that was actually radicalization. Having said that, I have also heard from prisoners more recently about their real concerns about radicalization that can happen. And of course, there are some very dangerous individuals who've committed terrorist offences in the prison system, and some of those individuals are very much intent on attempting to radicalize other prisoners. So I think it's a tricky issue. I don't think it's always helped by national media attention. But that's the lot of prisons, unfortunately. Often these issues only really get talked about when the media look at them.
Thank you. Let's move on. Time is against us, and we still have one more item to discuss. But if you're interested in that report, it's Terrorism in Prisons is the report. We'll send the link around with a follow-up email. And I think, like all of these kinds of official reports, you know, there's some very disappointing content in it and stuff that anyone is going, you know, different people are going to disagree about. There's also some interesting and useful content in it, and it's, you know, well worth the read. If only the executive summary, if you're interested in this kind of complex and challenging question. All right, let's move on. According to the new report out from the House of Commons Justice Committee, nearly 15,000 cases due before the Crown Court had been outstanding for a year or more. These form part of a growing backlog of nearly 60,000 Crown Court cases in December 2021, which was up 3% on the previous year. The backlog of outstanding cases in magistrates' courts, nearly 360,000, had fallen slightly from the previous year, but it was still 20% higher than in 2019. Meanwhile, barristers engaged in criminal defence and prosecution work have adopted a no returns policy, certainly for cases involving legal aid. And what this means is that they won't commit to covering for colleagues unable to take up cases, typically at short notice. The no returns policy comes as a result of a long-running dispute over the chronically underfunded legal aid system, which, according to the Criminal Bar Association, has led to an alarming exodus of barristers who specialise in criminal law. So all the makings of a perfect storm here, of courts backlog, you know, cases not progressing, and as we discussed in a previous edition of this programme, therefore more and more prisoners spending time on remand, waiting for their trial. But Hannah, the COVID lockdown has undoubtedly exacerbated the problem of the criminal courts backlog. But, you know, the Justice Committee themselves argued that the factors responsible for increased delays over the past decade are deep-rooted. So, you know, in a nutshell, what are the kind of leaving aside COVID, what are the main factors that have kind of contributed to the current rather difficult situation in the criminal courts?
The main one was a decision taken that fewer judges were allowed to hear cases. So if you walk into a Crown Court building, you will often find courtrooms sitting empty because as a budgetary cut, the Ministry of Justice said they weren't going to pay for as many judges to sit, so the days when they hear trials. So that had a huge impact on the backlog pre-COVID. The government is now trying to suggest lots of this is COVID related. The majority of it was pre-existing. They've also sold off a number of courthouses. If you think where courts are built, sort of prime inner city locations, some are very beautiful Victorian buildings, they were sold off and haven't been replaced. So it's largely financial. And then you've also got issues with an overworked Crown Prosecution Service and police force not necessarily being ready for trials on the day that they're supposed to be. So then there's cases get put off, and then trying to get everybody together for the same date leads to more and more backlogs. You've possibly also got different types of cases. We've got far more historical sexual abuse allegations. They can take quite a long time to actually get to court as well. Primarily it's funding, but increasingly it's becoming a case of not being able to get barristers to act in these cases. So you're seeing increasingly barristers or solicitors saying, you know, we tried to contact all these different chambers, there was nobody available to take this case. And that's because it's not a viable option for people to go into anymore. If you look at a barrister after 3 years work, so if you think about the debt you have to accrue to become a barrister, you have to do a law degree, you have to do the bar course, you have to do your pupillage, which is when you're sort of a trainee. 3 years after that, the median earnings are £12,000 a year. I mean, that's barely minimum wage. And
3 years after you've qualified.
Yes, and also lots of people aren't even earning that. So barristers themselves would be earning so little, they would be eligible for legal aid if they ended up being brought before the courts in a different capacity. So increasingly, law graduates are just saying, I like criminal law, but it's not sustainable as a career. And we're seeing the barristers taking action at the moment, but we've got a desperate problem with solicitors as well. The average age of a criminal solicitor is 48, I think 49. So once they've, come up to retirement, they can't be going to the police station throughout the night to represent clients. So it's going to be harder and harder for people to get legal representation at the police station, or it's going to be, sent out to call centres we're going back to the bad old days possibly of having, non-legally qualified people doing this kind of work. And there've been such improvements made. I think it's really frightening. There is a real existential threat to the criminal justice system in terms of lawyers, certainly.
And just in terms of court procedure, I mean, if a defendant is coming to trial, they're entitled to some form of representation. And that has to be, I mean, it couldn't just be, me turning up and saying, well, I'll represent you. It has to be someone who has the legal qualifications.
No, I think you can.
Oh, so I could
bring your mate along. It's a really bad idea.
But do they have a right to a kind of a properly qualified legal representative?
They do, but increasingly people have to pay for it. So
right.
If your household earnings or disposable income is over something like £30,000 maybe, you wouldn't qualify for legal aid. So, and this is the other absolutely iniquitous part of the system. If, say, I was tried for an offence, I had to pay privately, and I was acquitted, so a jury found me not guilty, I would only be entitled to what it would have cost at legal aid rates. So I could be left hundreds of thousands of pounds in debt. And we've seen examples of people having to sell their houses, use all their life savings, get, cash in pensions and things in order to, having cleared their name, because the government won't reimburse them. So it's like the secret barristers called it an innocence tax.
And there was a case of that some years ago when actually one of the current deputy speakers in the House of Commons was prosecuted and was acquitted and was then tens of thousands of pounds out of pocket. But it was actually he as an MP voted for the legislation that removed, some of the protections that he was then, found himself at the wrong end of the stick of, as it were. But
again, for a profession of advocates, I think these stories aren't being told. I mean, most people don't know this is happening and don't know about these problems until they are either a defendant, a victim, or a witness in a case. We need people to understand this, because if these trials aren't going ahead for long periods of times, witnesses will withdraw. We've seen a lot of coverage about the low rates of rape convictions. Well, if you're having to wait for 4 or 5 years for a trial, a number of complainants are going to say, I just need to move on. I can't keep gearing myself up for a case. And equally, defendants are living under the weight of this case hanging over them. But people who should be convicted won't be because of the delays, and people who are innocent or who should be acquitted are having to wait such a long time, and possibly a pressure to plead guilty. If you plead guilty, you'll get it over with. If you're waiting for a trial, it could be years.
And Deborah, I mean, these kinds of questions, they're not just kind of, as it were, dry questions of legal procedure, are they? Because, I mean, you, at the beginning, or earlier on in this programme, you posed the question, well, criminal justice, are you sure it's justice? But, I guess one mark of justice is that, defendants get good representation, and, the process of prosecution is pursued in a timely manner, so people aren't languishing on remand for months and months and months at a time, and that people who've been victimized feel there's some possibility of getting some kind of recourse, however kind of imperfect that is. So these are really kind of, I mean, these are as much political questions, aren't they, as well as kind of legal questions.
I'm on mute. I think you're right, they are political questions. Our government has made many decisions about what they will and won't fund. What was it called? Oh, legal aid. Legal aid is almost negligible now, and that has a real impact on people's ability to mount a serious defence. And I heard more recently, I mean, blaming Crown prosecution services, which are themselves underfunded, for the backlogging in case outcomes is reprehensible. I would have argued.
Thank you very much. And so I should probably have said maybe earlier, I think, Deborah, you're currently a a Labour councillor, is that right?
Yes, I am. I'm a Labour councillor.
So we should probably just have that declaration of interest, as it were, since we're talking about politics.
Please declare the interest, but I'm equally scathing.
Thank you very much. Hannah, sorry, did you have anything finally you wanted to say on that? No. Okay, well, look, Andrew, my apologies, yes.
I did one thing, which is I as somebody who's skeptical of how useful the criminal justice system is in terms of actually solving the harms that crime causes, if you just take the government on its own, face value, it is so frustrating to think that, if we manage to deal with the court's backlog, then we will have a prison population that might be 25% larger in 5 years' time, according to their projections. But if they don't do that, then what we have is a system where I think public trust will be at rock bottom, and that I think will then have a spiraling effect that impacts on reformers in a different way. And I think one of the things that I find that's so frustrating and enraging, actually, is that, successive governments talk tough on crime, but even on their own standards, they are unable to properly fund the system that they wish to deliver that tough on crime rhetoric. And as a sort of avoidance of that, they will probably announce further tough on crime policies elsewhere in the system, like lengthening prison sentences, without actually spending the money where it's really needed, or making fundamental decisions about what the system should look like, given where we're at.
Thank you very much indeed. We've ever so slightly overrun, but hopefully those watching will agree that it's been packed with content and was worth those extra few minutes. Look, thank you very much to Deborah, Hannah, and Andrew for giving us so much to think about and talk about. And I think it was a really good discussion, exploring a number of different perspectives of some really challenging issues this month. So thank you for your time and the generosity of spirit that you entered into some interesting discussions. And thank you also, of course, to all those who attended. And we'll follow on and watch this program on YouTube when we publish it, as we will, if not today, then certainly in the next few days. Our next Last Month in Criminal Justice is on June the 8th, not June the 1st, it's on June the 8th, Wednesday, June the 8th, and we'll be reviewing criminal justice developments in May. And between now and then, on the 18th of May, the 18th of May, we'll be having 16th of May, I think it is, isn't it? I'm going to have to check my diary now. Is it? We'll send the details about that. We have our 18th of May, we have our next lunch which is with Alex Vitale, the US scholar and activist and the author of the best-selling End of Policing. So if you're particularly interested in some of the questions about racialized policing, the problems of criminal justice criminalization and the degree to which the police act as an entry point into a whole systems of punishments that don't work, then lunch with Alex Vitale on the 18th of May, not to be missed. But for now, thank you very much for all those who attended today, and see you at our next lunch with and Last Month in Criminal Justice. Thank you very much.
Thank you.